Council, members of the jury, he went Rose. Today, you have heard the story about how my client, Avery Bancroft, was forced into bribing the chair of the Midlands Gambling Commission. My client, Avery Bancroft, submitted a proposal to the Midlands Gambling Commission in early February of 2015, hoping that he would be able to obtain a second casino license in Midlands in order to build another casino. But when my client submitted his proposal, he had no idea of the future that lay ahead for him. The future that lay ahead for my client after he submitted his proposal is a future of an undercover detective, Mickey Keenan, coercing him to bribe the chair of the Midlands Gambling Commission, Chase Covington. Officer Keenan started his investigation in the Midlands Gambling Commission with the expectations of finding corruption in the voting process of how the Midlands Gambling Commission operates their work. After about a year and a half of finding no hint of any evidence of any corruption, Officer Keenan decided that it was time that he steer this operation in the direction in which he wanted it to go. This is when Officer Keenan decided to go rogue. In order to get close to Mr. Bancroft, in order to pressure his ideas onto Mr. Bancroft, he enlisted in the help of Mr. Bancroft's executive assistant, Corey Hyde. He used Mr. Bancroft's assistant, Corey Hyde, in order to set up meetings between himself, Ms. Covington, and Mr. Hyde. That way he could pressure Mr. Bancroft into bribing the chair of the Midlands Gambling Commission. In these meetings, Officer Keenan made it very clear that the deal was not going to get done unless my client, Avery Bancroft, bribed the chair of the Midlands Gambling Commission, Chase Covington. We as the defense today are bringing up a defense of an affirmative defense theory. This simply means that we have to prove to you beyond the preponderance of the evidence that my client, Avery Bancroft, was induced to make this bribe to the chair of the Midlands Gambling Commission by a government official. By beyond the preponderance of the evidence, I mean that by 50% and a feather's weight, that you feel that my client was forced to make this bribe to Ms. Covington, that you must render him not guilty. Members of the jury, you have heard the testimony in trial today. There were 6 witnesses that appeared before you today. You heard Mr. Bancroft's own executive assistant say that it was Officer Keenan who first contacted him in order to talk about the proposals. That he had no prior knowledge of Officer Keenan, of Mr. Bancroft and Ms. Covington meeting to discuss proposals. That it was Officer Keenan who immediately jumped to the conclusion to get Mr. Bancroft to bribe Ms. Covington. You heard the witness, J.D. Lorian, say how there was no documentation of Mr. Keenan's training methods throughout any of his operation. That Officer Keenan had no documentation of his training methods, and that he clearly induced Mr. Bancroft to commit this bribery. You also heard Mr. Bancroft come up here and say that he had already bought the land in order for the casino to be built. Officer Keenan was aware that my client, Mr. Bancroft, had already bought this land, and he used that in order to pressure him even more to commit this bribery. But we as the defense are not the only ones with a burden to prove to you here before today. The prosecution also has to prove that Mr. Bancroft had a predisposition to commit this bribery. The prosecution did not prove their burden here before you today. The prosecution brought up witness Danny Hoy to testify that Mr. Bancroft wanted to know where the blind spots were in his casino. Mr. Bancroft was aware of these blind spots from 2014. These blind spots were of no concern to him going into 2015. He did not care about these blind spots. He was simply just having a security briefing with one of his employees. The defense also brought up the witness, Reese Warren. Reese Warren testified that Officer Keenan used open-ended questions and other strategies in order to have a good operation in his investigation. Our witness, J.D. Laurie, clearly proved that what Reese Warren said is actually false, that Officer Keenan did not use any of the proper techniques that he was supposed to use while operating an undercover operation. Members of the jury, as the defense, we come to you today and ask that you find my defendant not guilty.